Right, good morning class. We're resuming with the subject of tribunals. Okay, we are taking a look at, completed the first three parts of the tribunal chapter, looking at what is known as the current updates, right? Right? So, let me figure this point out. Very simply, we had taken a look at if we take a little bit of a summary of what we had covered yesterday, we had taken a look at number one, how are tribunals mentioned in the original constitution, Article 136. Then we had taken a look at Article 323A plus B under the 42nd Constitution Amendment Act 1976. This is where we had placed tribunals. Okay. Then we had taken a look at the judicial interpretations of it, the judicial ideas around it, which is basically about the two cases that we had discussed yesterday, which are contradicting each other, are the SP Sampath Kumar case and the L Chandra Kumar case. Right? Okay, so I think we have understood in the whole idea about these two judgments. If you can very simply take an understanding of them, is with regard to tribunals, whether they are what you can call the SP Sampath Kumar case said that the tribunals are fundamentally judicial bodies, right? And therefore, Parliament has a in right to enact amendments in the constitution to create alternate judicial bodies which can be substitute to the high courts, right? So they said that yes, they are judicial bodies, but they should not only be judicial bodies de jure, which means in law, but also must be judicial bodies de facto, which is in fact. Okay. And what L Chandra Kumar said was that the tribunals are what you can call, since they are not doing any activities, the tribunal, the government is not doing any activities to bring the tribunals appointment under independent commissions and committees, but is itself appointing all the members of tribunals. It is very much similar to not a judicial body but a administrative body. This is an administrative body which the tribunal is similar to. And therefore, the idea of tribunal being under the government is very clear, and therefore the High Court said that the Supreme Court said that the concept of Article 227, 226 and appeal will apply to the tribunal, and the High Court will stay in supervision of the tribunals because it is not a completely judicial body. Till the time it is completely judicial body, the High Courts will have the authority to make a kind of a intervention in the judgments of the tribunal under Article 226, 227 and appeal, because we have seen that writ petitions under Article 226 and under Article 332 are going to be applicable to the High Court, applicable to every executive body in the country. And since tribunal is an executive administrative body, it is something which will also be a part of this particular way of deciding over. Okay, right. So we take a look at this. Okay, so let me dictate the L. Chandrakumar case. So yesterday I had not dictated the L. Chandrakumar case, right? Write down the L. Chandrakumar case, second. 1997. L. Chandrakumar case, 1997. Write down. L. Chandrakumar case, 1997. L. Chandrakumar case, 1997. Write down. In this judgment, in this judgment, in this judgment, the Supreme Court, in this judgment, the Supreme Court overturned this judge of Supreme Court overturned the findings of the findings of the findings of findings of the SP Sampath Kumar case. SP Sampath Kumar case. SP Sampath Kumar case. SP Sampath Kumar case, which talked about tribunals being substitutes. Which talked about tribunals being substitutes. Which talked about tribunals being substitutes. Tribunals being substitutes. Of the High Court. Tribunals being substitute of the High Court. Tribunals being substitutes of the High Court. And tribunal being substitutes of the High Courts. Substitute of the High Court. Substitute of the High Courts as alternate judicial bodies. As alternate judicial bodies. As alternate judicial bodies. Comma. Instead, it held that. Comma. Instead, it held that. It held that the executive control over tribunals appointment. The executive control over tribunals appointment. Instead, it held that the executive control over a tribunal's appointment, instead that it held that the executive control over tribunal's appointment places them under the executive branch. Places them under the executive branch. And therefore they are not purely judicial bodies. They are not purely judicial bodies. judicial bodies and can be subjected to the power of the high courts and can be subjected to the power of the high courts under article 226 and 227 can be subjected to the power of the high court under article 226 and 227 can be subjected to the power of the high court under article 226 and 227 can be subjected to the power of the high court under article 226 and 227 subjected to the power of the high court under article 226 and 227 comma it also declared that judgments orders of tribunals that the orders of tribunals are subject to can be appealed before a division bench of a high court. Orders of tribunals can be appealed before a division bench of a high court. Before a division bench of a high court. Full stop. This law or this case law still applies today. This case law still applies today. This case law still applies today. This case law still applies today and holds that this case law still applies today and holds that High Court has review powers over tribunal's order. High courts have review powers. High courts have review powers over tribunal's orders. High courts have review powers over tribunal's orders. Review powers over tribunal's orders. High Court has review powers over tribunal's orders. Okay, full stop. Okay, so this is the next case that we have taken a look at. Okay, this is a judgment given by the Supreme Court in which the Supreme Court has itself given the summary of it. So you can take a look at this. You have, for example, in L. Chandra Kumar versus Union of India, this court held that the power of judicial review vested in the high courts, and this court under Article 226 and 227 and 32 is a part of the basic structure of the Constitution. The power of the judicial review vested in the high courts, and this court under Article 226 and 227 and 32 is a part of the basic structure of the Constitution. Okay? Therefore, the court held that the tribunals cannot act as substitutes of the high courts, and this court and their functioning is only supplementary, that all decisions of administrative tribunals will be subject to scrutiny before a division bench of the respective high courts. Addressing the issue of the dependence of tribunals on the executive or administrative requirements, a recommendation was made for creation of a single umbrella organization which will be an independent supervisory body to oversee the working of the tribunals. This court was also of the opinion that the Ministry of Law and Justice, Government of India should be the nodal ministry. Okay? Right, so this is basically the L. Chandra Kumar case. Now, some kind of a development happens later on, which leads to another case in around 2010. Okay, you have, for example, the Madras Bar Association cases starting over here. So we're starting after the L. Chandra Kumar judgment. We're moving on to the third point. After the L. Chandra Kumar judgment, we are moving on to the third point, which is about the fact that there is what you can call uh, a 2010 judgment as to what Supreme Court has said on this particular matter about tribunal's nature. Right? So let's take a look at a summary of this. This is with regard to a new law made by the Parliament, which was about the establishment of the National Company Law Tribunal. Okay, so Part 1B and Part 1C were inserted in the Companies Act 1956, providing for the constitution of the National Company Law Tribunal and the National Company Law Appellate Tribunal. Okay, Part 1B and Part 1C were inserted in the Companies Act 1956, providing for the constitution of the National Company Law Tribunal and the National Company Law Appellate Tribunal. Okay, full stop. Madras Bar Association filed a writ petition in the Madras High Court challenging the wires of the above provisions on the grounds of violation of rule of law, doctrine of separation of powers, and the independence of judiciary, which are essential features of the basic structure of the Constitution. Okay, just take a look at this summary a little bit. The government of India had amended the Companies Act 1956 to introduce the concept of the National Company Law Tribunal and the National Company Law Appellate Tribunal, right? So you had created two tribunal bodies which were supposed to take away all the matters from the High Court and the Supreme Court on the subject matter of company law, corporations, right? Though Companies Act and company law is a huge set of litigation before the Supreme Court and the High Court. The tribunals were created separately to take care of all that litigation matter and not have any of them remaining with the Supreme Court or the High Court. Okay, so the Madras Bar Association challenged in a writ petition before the Madras High Court, challenging the wires. Wires means the legitimacy, you can say the competence of the Parliament to make such a law, because it violated the basic structure of the Constitution. The Madras High Court allowed the writ petition, which was subject matter of several appeals, which were disposed by this court in the Union of India versus R. Gandhi, President of Madras Bar Association. So the eventual point came to the Supreme Court, where Supreme Court had finally taken a look at this matter, and the answer was given in Union of India versus R. Gandhi, President Madras Bar Association. Okay. So you see the fact that the Union of India versus R. Gandhi, President Madras Bar Association. This court was of the opinion that while it cannot be said that the legislature is denuded of the power to transfer judicial functions performed by courts to tribunals, nevertheless, independent judicial tribunals for determination of the rights of citizens and for adjudication of the disputes and complaints of the citizens is a necessary concomitant to of the rule of law. It was held in the above judgment that the judicial independence and separation of judicial power from the executive are part of the common law tradition implicit in a constitution like ours. The creation of NCLT and NCLAT was upheld. However, the defects found in parts 1B and 1C of the Companies Act were directed to be rectified by suitable amendments, with modifications suggested by this court in order to uphold the judicial independence of the tribunals. The suggestions pertain to the composition of a search cum selection committee for appointment of members of the tribunals, qualifications for appointment, and service conditions of members of the tribunals, right? So this is whole kind of a repetition of the SP Sampath Kumar case done by the Supreme Court in this particular case. Okay, so in the SP Sampath Kumar case, the Supreme Court had held exactly this, that the the composition of the tribunals has to be properly managed. Okay, so the judgment of the R. Gandhi case was something that the Supreme Court had again in a way reflected back and said that yes, these are judicial bodies, but they cannot be completely judicial bodies without the fact that they are also making sure that the appointments are done properly, right? So the aggressive step taken by the L. Chandrakumar case was in a way toned down by the Supreme Court again in the R. Gandhi versus the Union of India case, right? So we can write down the third case. Please write down. R. Gandhi, R. Gandhi, President of Madras Bar Association, case 2010. R. Gandhi, President of Madras Bar Association, case 2010. R. Gandhi, President of Madras Bar Association, case 2010. R. Gandhi, President of Madras Bar Association, case 2010. Okay. So, write down the first point under this. In fact, just write down. The Companies Act, the Companies Act, the Companies Act was amended by the Parliament, was amended by the Parliament, by the Parliament, by the Parliament to introduce the provision of, to introduce the provision of the National Company, the National Company Law Tribunal, NCLT, the National Company Law Tribunal, and the National Company Law Appellate Tribunal. National Company Law Tribunal and the National Company Law Appellate Tribunal was amended by the Parliament to introduce the National Company Law Tribunal and the National Company Law Appellate Tribunal, NCLAT. Okay? Comma. This was challenged by the Madras Bar Association. This was challenged by the Madras Bar Association before the Supreme Court. Before the Supreme Court. Before the Supreme Court as being violative of rule of law, as being violative of rule of law, as being violative of rule of law, separation of powers, as being violative of rule of law, separation of powers, as being violative of rule of law, separation of powers, and rule of law, separation of powers, and independence of judiciary. Independence of judiciary. Independence of judiciary, full stop. Okay. The Supreme Court did not declare the NCLT and NCLAT as unconstitutional. The Supreme Court did not declare NCLT and NCLAT as unconstitutional. The Supreme Court did not declare NCLT and NCLAT as unconstitutional, but NCLT and NCLAT as unconstitutional, but it directed modifications. It directed modifications in the law to make the appointment of the tribunal members. Modification in the law to make the appointment of the tribunal members. Modification in the law to make the appointment of the tribunal members. Modification in the law to make the appointment of the tribunal members. Make the appointment of the tribunal members free from the executive control. Free from the executive control. Free from the executive control. By composing a search cum selection committee. By composing a search cum selection committee. By composing a search cum selection committee. Full stop. Okay, so this is the third case. Okay, I'm just very categorically making it clear to you what are the cases which were involved in this particular category of things, right? The first case that was involved was what you call the idea of the SP Sampath Kumar case. This is 1987. Okay, then you have the L Chandra Kumar case. This is 1997. Then you have the R. Gandhi, President of Madras Bar Association case, 2010. Right. So I'm hoping that you're able to take a good memorization of this index of cases that we are creating with regard to this. Okay. The Madras Bar Association was very active in, calling out a lot of questions with regard to the tribunals. Okay. So Madras Bar Association later on had questioned the constitutional validity of the National Tax Tribunal Act 2005. This court held that the National Tax Tribunal Act to be unconstitutional. Nonetheless, the vesting of adjudicatory functions in tribunals was held not to be violative of the basic structure of the Constitution. Okay. So again, another case happened in which the Supreme Court, this is the Madras Bar Association versus Union of India. Okay. So just take a fourth case over here, so that you can create a list of all these cases. Madras Bar Association versus Union of India. Madras Bar Association versus Union of India, 2014. Let's write down. Madras Bar Association versus Union of India, 2014. Write down. The Bar Association had questioned the formation of National Tax Tribunal in 2005 of 2005, sorry. National Tax Tribunal of 2005. Bar Association had questioned the formation of National Tax Tribunal of 2005. National Tax Tribunal of 2005. National Tax Tribunal of 2005. And the Supreme Court had held it to be unconstitutional. The Supreme Court had held it to be unconstitutional for violating independence of judiciary. For violating independence of judiciary. By not making the members free from executive control. By not making members free from executive control. By not making the members free from executive control. By not making the members free from executive control. By not making members free from executive control. Full stop. But it retained the principle, full stop. But it retained the principle, that the Parliament has competence. Parliament has competence. Parliament has competence to to allocate judicial functions. Allocate judicial functions to tribunals. Parliament has the competence to allocate judicial functions to tribunals. To allocate judicial functions to tribunals. Allocate judicial functions to tribunals. Allocate judicial functions to tribunals. Okay, so you have the case in which this was happening. Okay, again you have, it's like you see the court over here is kind of sick of looking at this, because if you look at this judgment, now this is a judgment given by the Supreme Court in one of the cases in which Supreme Court itself is laying out a kind of a summary of what has happened in the past. Look at how Supreme Court talks about it. It says, with regard to the questions of tribunals, look at what it says. The court is once again within a span of a year called upon to decide the constitutional of various provisions concerning the selection, appointment, tenure, conditions of service and ancillary matters relating to various tribunals, 19 in number, which act in aid of the judicial branch. That the judicial system and this court in particular has to live these deja vu moments time and again, exemplified by no less than 4 constitution bench judgment in the last 8 years. Okay, so speaks profound volumes about the constancy of the other branches of governance in their insistence regarding these issues, right? So the Supreme Court itself is saying that there are judgments which we have to make almost every 2 years with regard to this, and something other than that also comes out. So we've already taken a list of 2 judgments. One is in 2010, one is in 2014 in the recent past when the Supreme Court has been involved in this particular matter, right? But that's not it. You have, for example, after that, the 2014 judgment, there was another court, another case which regard to said that the Companies Act 2013, the Companies Act 2013 replaced an earlier act of 1956 in which amendments were made to provisions relating to establishment of NCLT and NCLAT, right? So a new Companies Act was brought by the government in 2013, right? So first you have a Companies Act of 1956. The first Companies Act that was there in India was in 1956, but a new Companies Act was brought about in 2013. A new Companies Act was brought about in 2013. And this Companies Act was again, the government was playing cat and mouse again. They reintroduced the NCLT and NCLAT again with the whole issue of appointment, etc., etc. So a writ petition was filed under the Article 32 by the Madras Bar Association, again deja vuing it, questioning the amended provisions of chapter of the Companies Act, and more particularly section 408, 409, 411, 412, 413, etc., etc. The complaint of the Madras Bar Association said it was that the offending provisions were analogous to the provisions of the 1956 Act, which were found to be unconstitutional by this court, right? So the constitutional validity of the provisions of chapter 17 of the Companies Act 2013 was upheld by a judgment in Madras Bar Association, in Madras Bar Association versus Union of India, right? This court was of the view that certain provisions relating to the composition of search, selection committee and qualification members of tribunals are invalid as they are contrary to directions issued by the earlier judgment of the Supreme Court, right? So here, take a look at this. This is a judgment which is known as the Madras Bar Association versus Union of India 2005. You can take a look at this. Okay, so that's again the same name of the judgment, because as I was telling you, Madras Bar Association is quite proactive in taking these cases up. But the fourth judgment that you can order into this, perfect this idea, After the fifth, so the fifth judgment that you can add into this is Madras Bar Association versus Union of India 2015. Versus Union of India 2015. Okay, please take a look at this and let's write down a little bit of a brief about it. Madras Bar Association versus Union of India 2015. Madras Bar Association versus Union of India 2015. Versus Union of India 2015. Okay, write down a brief about it. Madras Bar Association versus Union of India 2015. Write down. In 2013, a new Companies Act. In 2013, a new Companies Act. In 2013, a new Companies Act was enacted, which had provisions analogous to, was enacted, which had provisions analogous to, the new Companies Act was enacted, which had provisions analogous to, analogous to the 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 provisions of amendments in the 1956 Act regarding NCLT and NCLAT. Regarding NCLT and NCLAT. Regarding NCLT and NCLAT. Regarding NCLT and NCLAT. Okay, in 2013, a new Companies Act was enacted analogous to the 1956 Act, the provisions regarding NCLT and NCLAT. Full stop. This was challenged by the Madras Bar Association before the Supreme Court in 2015. This was challenged by the Madras Bar Association before the Supreme Court in 2015, which again declared these parts as unconstitutional. Which again they declared these parts as unconstitutional. Again declared these parts as unconstitutional because of violation of separation of powers, and independence of judiciary. Violation of separation of powers and independence of judiciary. Violation of separation of powers and independence of judiciary. Separation of powers and independence of judiciary. Full stop. Okay. Independence of separation of powers and independence of judiciary. Full stop. Okay, so this is the fifth case in this regard. Okay. Now take a look at this. The Finance Act of 2017 yeah. The Finance Act of 2017 amendments were made to certain acts to provide for merger of tribunals and other authorities and conditions of service of chairpersons, members, etc. According to Section 183 of the Finance Act 2017, the provisions of Section 184 shall apply to the chairperson, vice chairperson, chairman, vice chairman, president, vice president, presiding officer, or member of the tribunal or appellate tribunal or other authorities as specified in the 8th schedule. Okay, what does this mean? Section 184 empowered the central government to make rules to provide for qualifications, appointments, terms of office, salaries and allowances, resignation, removal, and other terms and conditions of service of chairperson, vice chairperson, etc. etc. Okay. So this is again, first of all, let's get a little bit of a clarity on things. The nodal ministry, the nodal ministry under which the tribunals are in a way a combination of two ministries. Okay, the finance ministry has the portfolio of tribunals and the concerned ministry. For example, if you take a look at the National Green Tribunal, National Green Tribunal is under the Ministry of Environment. Okay, so the portfolio of tribunals is a kind of a very unique mixture between two ministries under the concerned ministry of the subject under which it is formed, but also under the finance ministry. Right? A lot of speculations say that it has been kept under the finance ministry because a finance act or any kind of other money bill allows the government to change the composition of tribunals by passing the Rajya Sabha. Bypassing the Rajya Sabha. Right? You know for a fact that finance bill or a finance act is a money bill. Okay. And if you have a money bill in the parliament, you do not need the voting of the Rajya Sabha in support of that bill. Okay, let me repeat it again. You have the finance act or the finance bill, and the whole point is that if you are introducing it as a finance act, then it is a money bill, and by money bill you can bypass the Rajya Sabha. So that makes it easier for the parliament, especially the Lok Sabha or the ruling government, ruling political party in the Lok Sabha, to have a kind of an activity in this regard, in which a kind of system is created for the passing of a tribunals, right? So by the Finance Act 2017, the central government was empowered itself to make rules to provide for qualifications, appointment, term of office, salaries and allowances, resignation, removal and other terms and conditions service of the chairperson, vice chairperson, etc. Okay. So you see the whole idea was to create a kind of a structure of appointment of the chairpersons and presiding officers of tribunals by the central government. Again, the central government had assumed the position of doing it in amending the Finance Act. Okay. Maximum tenure for aforementioned persons was fixed as 5 years. Chairpersons, chairman or presiding officer of tribunals cannot continue beyond 70 years. Likewise, the vice chairman, vice chairperson, president, etc. shall be entitled to continue till they are attaining the age of 67 years. The validity of the Finance Act and the tribunal, appellate tribunal, other authority rules 2017 came up for consideration in this before this court in Roger Matthew versus South India Bank Limited. Right now, this is the sixth case in this regard. Again, all of this went to the Supreme Court. Okay, so take a look at the sixth case that I'm adding over here. Roger Matthew Roger Matthew versus South Indian Bank. 2020. This is a case again that goes to the Supreme Court with regard to the appointment of the members of the tribunal kept under the control of the central government. Okay, take a look at this. The issue pertaining to whether the finance bill was a money bill and if not, the need for it to be passed by the Rajya Sabha was referred to a larger bench, and it was held that Section 184 of the Finance Act does not suffer from excessive delegation of legislative functions. The 2017 rules were struck down as being contrary to the principles of Constitution as interpreted by various decisions of this court. The central government was directed to reformulate the rules strictly in conformity and in accordance with the principles delineated by this court in its earlier judgment, read by the observations made in the Roger Matthew judgment. Non-discriminatory and uniform conditions of service, including assured tenure, were directed to be formulated by the central government in the new set of rules. A writ of mandamus was issued to the Ministry of Law and Justice to carry out a judicial impact assessment for all the tribunals. Appointment to the tribunals, appellate tribunals, and other authorities were directed to be held in accordance with the respective statutes which govern the conditions of service of members of tribunals before the enactment of the Finance Act, till a fresh set of rules were made by the central government. The Union of India was granted liberty to seek modification of the said order by a fresh rules were filed. Okay, so this is again another case, very simply about how the government of India, again the Union government of India, again made a set of rules and they were again struck down by the Supreme Court. That is why the Supreme Court judges have made a point about the saga of how the government is very insistent upon doing something. So you see, it's a kind of classic tussle between the legislative executive on the one hand and the judiciary on the other hand. You see this kind of a Tom and Jerry game going on between the two. Okay, write down the case about this. Roger Matthew versus South Indian Bank. Please write down. Roger Matthew versus South Indian Bank. Please write down. Please write this one down. The Finance Act 2017, the Finance Act 2017, brackets में, passed as a money bill. The Finance Act 2017 passed as a money bill. Finance Act 2017 passed as a money bill. Finance Act 2017 passed as a money bill. As a money bill. As a money bill. Create under section 184. Under section 184. Laid out requirements. Laid out conditions and procedures. Laid out conditions and procedures. Under section 184 laid out conditions and procedures that pertained with the appointment of chairpersons, and members of various tribunals. Comma. This act and the corresponding rules. This act and the corresponding rules. This act and the corresponding rules. This act and the corresponding rules were challenged. This act and the corresponding rules were challenged before the Supreme Court, on the question of separation of powers and judicial independence, on the question of separation of power and judicial independence, on the question of separation of powers and judicial independence, question of separation of powers and judicial independence, comma, the Supreme Court declared these provisions of the Finance Act 2017 as unconstitutional. Declared these provisions of the Finance Act 2017 as unconstitutional. Declared these provisions of the Finance Act 2017 as unconstitutional. Declared these provisions of the Finance Act 2017 as unconstitutional. Okay? Right? So hopefully that's again another thing. And the story is still not over. Okay? Thereafter, by a notification dated 12 February 2022, the central government, in exercise of the powers conferred by Section 184, made the impugned 2020 rules. The 2020 rules, which deal with qualification and appointment of members by recruitment, procedure for inquiry into misbehavior, house rent allowance, and other conditions of services, are the subject matter of challenge in these cases before us, and will be dealt with in detail in the succeeding paragraphs. Right. So this case, the case which is being discussed in the Supreme Court right now, the case to which we are looking at a summary, is rules made by the Government of India in 2020, which are again dealing with the whole question of the recruitment and appointment of the members of tribunals and chairman of tribunal. And this is known as the Madras Bar Association versus Union of India 2020. Right? This is the seventh case in the matter which we're taking a look at. Let's take a look at this one. And this is not final also. Again, in this case also, the Supreme Court tells the government that it cannot do it. 2020. Write down please this one. Please write down the judgment on this one. The Government of India in 2020 notified the Government of India in 2020 notified a set of rules under the Finance Act 2017. Set of rules under the Finance Act 2017. A set of rules under the Finance Act 2017. A set of rules under the Finance Act 2017. Finance Act 2017. A set of rules under the Finance Act 2017, which again prescribed for its control over the appointments, which again prescribed for its control over the appointment, over the membership of tribunals. membership of tribunals. Okay. Okay. Let us just read the Supreme Court itself when it has got a little tired about this cat and mouse game finally. What does the Supreme Court say? Dispensation of justice by the tribunals can be effective only when they function independent of any executive control. This renders them credible and generates public confidence. You understand this point? Dispensation of the justice by the tribunals that can be effective only when they function independent of any executive control. This renders them credible and generates public confidence. We have noticed a disturbing trend of the government not implementing the directions issued by this court. To ensure that the tribunals should not function as another department under the control of the government executive, repeated directions have been issued which have gone unheeded, forcing the petitioner to approach this court time and again. It is high time that we put an end to this practice. Rules are framed which are completely contrary to the directions issued by this court. Upon the tribunals has developed the task of marking boundaries of what is legally permissible and feasible as opposed to what is not lawful and indefensible conduct in a normative sense, guiding future behavior of those subject of the jurisdictions of such tribunals. This task is rendered even more crucial given that appeals against their decisions lie directly to the Supreme Court and public law intervention on the merits of such decisions is all about excluded. Also, these tribunals are expected to be consistent and therefore adhere to their precedents in as much as they oversee regulatory behavior in several key areas of the economy. Therefore, it is crucial that these tribunals are run by a robust mix of experts, that is, those with experience in policy in the relevant field and those with judicial or legal experience or competence in such fields. The functioning or non-functioning of any of these tribunals due to lack of competence or understanding has a direct adverse impact on those who expect effective and swift justice from them. The resultant fallout is invariably an increased docket load, especially by recourse of Article 226 of the Constitution of India. These aspects are highlighted once again to stress that these tribunals do not function in isolation but are a part of a larger scheme of justice dispensation envisioned by the Constitution and have functioned independently and effectively to live up to their mandate. The involvement of this court in the series of decisions rendered by no less than 6 constitution benches underscores the importance of this aspect. The role of both the courts as upholders of judicial independence and the executive as the policy making and implementing limb of governance is to be concordant and collaborative. This court expects that the present directions are adhered to and implemented so that in future litigation is avoided. The government is accordingly directed to strictly adhere to the directions given above and not force the petitioner, the Madras Bar Association, which has been relentless in its efforts to ensure judicial independence of the tribunals, to knock the doors of this court again and again. You see? So you kind of sense the frustration of the Supreme Court also with regard to the government rehashing the entire procedure again and again under different disguises and presenting it as a kind of a control of the tribunal members by the government directly. Right. So you can go and write the, put a full stop over here. The Supreme Court in this case, the Supreme Court in this case declared 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 the 2020 rules 2020 rules as invalid for violating independence of judiciary, as invalid for violating independence of judiciary, as invalid for violating independence of judiciary. Okay, you see, so this is one point. Then you can come to the third topic. I am just dealing with, these are the 7 cases that we have taken a look at. I hope you can take a look at the list of these 7 cases, starting from the SP Sampath Kumar in 1987 to the case in 1997, to the case in 2010, to the case in 2013, 14, 15 and 20. We have 2 cases about it. So we have taken a look at how this kind of a thing has developed thus far. Okay. Now you come to the third point, which is current updates. I think the last point, point number D, current updates on tribunals. Okay, this is what we are taking a look at today. What is happening now in 2021? In 2021, the Parliament, sorry, the Government of India, actually, the President issues an ordinance. Issues an ordinance which is known as a tribunal reform. Issues an ordinance which is known as a tribunals reform ordinance 2021, in which they give effect to what is the Supreme Court told was search cum selection committee. And there were certain other points made by the Government of India with regard to the search cum selection committee, which means that it is going to be a kind of a umbrella organization. A search cum selection committee is going to be an umbrella organization which is going to be responsible for search cum selection committee is going to be an umbrella organization responsible for search cum selection committee is going to be an umbrella organization responsible for the appointment of the members of tribunals. Okay, so for example, search cum selection committee would be like a committee. It will have the prime minister, it will have one union minister, it will have one leader of opposition, it will have one judge of the Supreme Court, it will have the chief justice of Supreme Court. You know, it's like a, maybe you can think of it as an NJSC kind of a structure. You see, an NJSC kind of a structure has to be created by the government. I was created by the government in these ordinance, which was issued by the government to create a search cum selection committee. Now, this search cum selection committee, again dealing with the question of the what you call the independence of judiciary, etc., was again challenged before the Supreme Court. So the Supreme Court had taken a note of the tribunals challenges given by the judiciary. Let's take a look at this. Oh, this is the last set of things that happens over here. So you see, in April 7, 2021, government issues tribunal reforms ordinance. Okay, tribunal reforms rationalization and conditions of service ordinance 2021 issued by the Ministry of Law and Justice was notified on April 4. Okay, take a look at this. The government has issued an ordinance which does away with certain appellate tribunals, including film certification, etc. So it was a huge movement of reforming tribunals. Okay, just take about 1 minute, though it is not going to be very important for us with regard to tribunals, but just as a current update, take a look at what the government has done under this. It has taken a lot of tribunals and abolished them, merged them, in a way what is known as a rationalization of tribunals, that the tribunals are proliferating beyond a point and it is not serving the purposes of justice. So the government has started doing a mission mash of these tribunals. Take a look at this part and see what we are taking a understanding of. Just see, just 1 second, pause for 1 minute and take a look at what the aspects of the tribunal reforms ordinance are. And this has been passed as an act by the government later on, so it is implemented already. right? So you get a sense of what is this, right? The Tribunal Reforms Rationalization issued by Ministry of Law and Justice was notified on April 4. It has made amendments to the Cinematographic Act, Copyright Act, Customs Act, Patents Act, etc., 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 and has done a huge refurbishment of the tribunals. In February, the government introduced a bill to abolish some tribunals where public at large is not litigant. The bill was introduced in the Lok Sabha by Minister of State of Finance Anurag Singh Thakur. You would understand why the Ministry of Finance would be involved in this. With a view to streamline tribunals, the Tribunal Reforms Rationalization Bill is proposed to be enacted to abolish certain tribunals and authorities and to provide a mechanism for filing appeal directly to the Commercial Court of the High Court, as the case may be, the statement said. Since the bill could not get parliamentary nod, an ordinance was issued. The Government of India began the process of rationalization of tribunals in 2015 by the Finance Act 2017. Seven tribunals were abolished or merged based on functional similarity. Okay, so you see a Tribunal Reforms Act which also had a kind of a position for the Search cum Selection Committee. The Supreme Court in August 16, you see April, you see the Tribunal Reforms Act coming. In August, the Supreme Court says a challenge to it. Okay. Supreme Court on Monday challenged the government to produce material showing the reasons for introducing the Tribunal Reforms Bill, which abolishes 9 appellate tribunals and revised position of an ordinance struck down by the Supreme Court and the Parliament. Okay, a 3-judge bench of the led by the put the government on the dock about the complete absence of material justifying the bill and also the lack of proper debate. Okay, so 1 second. Just 1 second. There's one thing I missed out in the middle. Yeah, this is the point that we have to read. The fact that the Tribunal Reforms Ordinance was introduced, later on the Supreme Court, when it looks at the Tribunal Reforms Ordinance, it says this. The Supreme Court on Wednesday by 2-1 majority set aside the provisions in the Tribunal Reforms Ordinance, which fix the term of members of various tribunals as 4 years. The majority comprising of Justice L. Nageshwar Ravindra Bhatt held that this term violated the express direction given in the earlier judgments in the Roger Matthew and the State of Madras Bar Association case. Right. So the whole point was that the Supreme Court again takes a kind of a striking down of the judgment given by the Tribunal Reforms Act. Yeah. In July 2021, the bench comprising of Justice L. Nageshwar Rao, etc., had struck down parts of the Tribunal Reforms Rationalization Condition of Services Act. The ordinance dissented. Okay, so the Supreme Court again itself took a note of this particular act and it struck down this act completely. Not completely, in part. The ordinance was struck down by the Supreme Court in part, saying that again the whole thing about the what you can call the violation of independence of judiciary and all of these things, etc., etc. So these are the cases which you're taking a look at. Okay, so this is the 2021 judgment by the Supreme Court, again known as the Madras Bar Association versus Union of India 2021. So in the current updates, you can write the first part over here. Okay, in current updates, write down the first point. Within current updates, write down the first point. In 2021, in 2021, the president in 2021, the president issued an ordinance. In 2021, the president issued an ordinance. The president issued an ordinance. In 2021, the president issued an ordinance. Issued an ordinance by the name of Tribunal Reforms Ordinance. By the name of Tribunal Reforms Ordinance. Issued an ordinance by the name of Tribunal Reforms Ordinance 2021, 2021, which provided for the rationalization of tribunals in India, which provided for the rationalization of tribunals, which provided for the rationalization of tribunals, and 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 a mechanism for appointment of tribunals, of members, a mechanism for appointment of tribunal members, appointment of tribunal members via the search cum selection committee, via the search cum selection committee, via the search cum selection committee. Full stop. This was challenged before the Supreme Court. This was challenged before the Supreme Court in the present case. This was challenged before the Supreme Court in the present case. This was challenged before the Supreme Court in the present case of Madras Bar Association, Madras Bar Association versus Union of India 2021. Madras Bar Association versus Union of India 2021. And the Supreme Court declared parts of this ordinance as unconstitutional. Supreme Court declared parts of this ordinance as unconstitutional relating to appointment, relating to appointment, relating to appointment, relating to appointment, full stop. Okay, you get the point? Now what the government does? The government takes the same thing exactly written in the ordinance and it issues what you can call this as a parliament. Take a look at this. This is a Hindu editorial on the same matter. Recent development demonstrated the union government's implacable determination to undermine the autonomy of various tribunals in the country. It recently got Parliament to enact the Tribunal Reforms Act, which contained provisions that had been struck down by the Supreme Court in an ordinance issued earlier. Okay. After being sharply questioned by the Supreme Court on the unusual delay in filling up vacancies among judicial and administrative members, it released a set of appointments this week. The court found that there was a cherry picking among the names chosen by the various selection committees. Instead of exhausting the selection list put together by panels of judges and officials, the government had waded into the waiting list to exercise its choice. In another development, the government cut short the tenure of the acting chairperson of the NCLAT by 10 days. Mr. Chima was set to deliver in some matters on which the NCLAT had reserved judgment before retiring on September 20. Okay, so you see the point? Just take a look at what is written over here, and just the bare minimum details upon this can give you an example of what the government is in a way trying to achieve with this entire thing. The idea is very simply determined as a fact that the government is interested at this point of time to very clearly cherry pick the members of tribunals, as you can see what is happening over here. So once the tribunal reforms ordinance was struck down by the Supreme Court, the government immediately after that brought the same ordinance before the parliament and passed it as a Tribunal Reforms Act, which contained the provisions that had been struck down by the Supreme Court in an ordinance issued earlier. You see, after being sharply questioned by the Supreme Court on the unusual delay in filling up the vacancies among judicial and it released a set of appointments this week. The court found that there was a cherry picking among the names chosen by the various selection committees. Instead, the exhausting the selection list would put together by panels of judges and officials, the government had waded into the waiting list to exercise its choice. You see the point? So here we have to take a look at and understand the way in which the government of India has now again once more taken a dig at the Supreme Court. The government's justification was that it was going by its latest law under which the acting chairperson's 4-year tenure would end on September 10 and that the Justice M. Venugopal had already been appointed in his place. However, a bench headed by the Chief Justice of India, N.V. Ramana, was of the strong opinion that he should be allowed to complete his tenure and even remarked that the court would not hesitate to stay the operation of the act on its own motion. Fortunately, the matter was resolved quickly with the government backing down and agreeing that Justice Venugopal would go on leave until Justice Kima finished his stint on September 20. The issue of tribunals has been a source of considerable friction between the government and the court. They have often disagreed on the eligibility criteria and conditions of service, and series of judgments have gone against the government. Clauses introducing changes to the conditions of service of members of the various tribunals have often been subjected to judicial review. Courts want to ensure that a reasonable tenure was available to the appointees and do not allow criteria related to age and experience to be used to undermine their independence. Tribunals have always been seen as institutions that were rung lower in independence as regular courts, even though there is a wide agreement that administrative tribunals are required for quicker and more focused adjudication of cases that require specialization and domain expertise. After several laws now provide for such adjudicative bodies, the executive does have an interest in retaining some leverage over their members. The Supreme Court has repeatedly called for the establishment of a National Tribunals Commission, NTC, to make suitable appointments and evaluate the functioning of tribunals. If the government has been dragging its feet on this, it is only because there is a method to its maliciousness. Right? So you get the point about it? A classic modern day example of a conflict between the government and the judiciary. We're coming to the fag end of this very complicated issue, and I'm covering every last detail that you would need to have an understanding upon this in proper terms. Okay, so let's take a look at the second point over here. In current updates, write down the second point. Immediately after the above judgment, immediately after the above judgment, immediately after the above judgment, the government presented the ordinance, the government presented the ordinance, before the parliament, which passed the Tribunal Reforms Act 2021, which passed the Tribunal Reforms Act 2021, which passed the Tribunal Reforms Act 2021, comma. The Supreme Court took note of this. Supreme Court took note of this. Supreme Court took note of this and held that and held that held that the passing of an ordinance which was struck down held that the passing of an ordinance which was struck down and held that the passing of an ordinance which was struck down passing of an ordinance which was struck down by this as an act as an act amounts to the dishonor of the Supreme Court. 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 And raises the key question. And raises the key question. And raises the key question as to why. And raises the key question as to why the. Sorry, not why. As to whether it is constitutional. It is constitutional of the Parliament. Whether it is constitutional of the Parliament to. Whether it is constitutional of the Parliament to. Constitutional of the Parliament to pass an enactment of an ordinance which has been struck down by the Supreme Court. Pass an enactment of an ordinance which has been struck down by the Supreme Court. Pass an enactment of an ordinance which has been struck down by the Supreme Court. Struck down by the Supreme Court. Full stop. Now you see, this is the point of time where we are here today, and this is what you will have to cover on your own with regard to the current affairs in it. This is a pending case before the Supreme Court. Okay, you have 3 judges, including the Chief Justice of India, who are going to take a look at this matter. Petitioner Madras Bar Association, Jairam Ramesh, Amit Sahni, Delhi Bar Association, and respondent Union of India. Okay, the point about this is the court will decide whether the Tribunal Reforms Act 2021 is unconstitutional for reenacting provisions that were struck down in the Madras Bar Association versus Union of India for violating the independence of judiciary. You see the point? So this is the thing which is pending, where the Supreme Court, Chief Justice of India and the government are going to finally take a tussle to the next level, where you have seen, for example, the government of India being completely relentless in doing things with regard to the tribunals, and the Supreme Court again and again, making a kind of a striking down of it. Yeah, so this has not been listed yet. Recently it was listed on 31st May, but nothing happened in that particular matter over there. But this is going to come up in the run up to the elections, with the government of India and the Supreme Court having an important kind of a conflict with each other. Okay, just take a look at this again. Tribunal Reforms Act 2021, Madras Bar Association versus Union of India. This will be called 2023. Okay, this is the judgment which is going to be given by the Supreme Court. The court will decide whether the Tribunal Reforms Act is unconstitutional for reenacting provisions that were struck down in the Madras Bar Association versus Union of India, which is the ordinance for violating the independence of judiciary. This is as simple as it can get. Right? So I hope you get a point as to what you are taking a look at in terms of finding a way to deal with this kind of a situation, an idea. Right? These are the things that we'll have to take a look at on your own once this kind of a thing is coming out. Okay. So just write down the next point. After this, point number 3, current updates, and then you can leave about 1.5 pages to update it yourself. When this judgment of the Supreme Court comes, the whole newspaper would be flooded with what the Supreme Court has said in this regard again. Okay, so just write down the third point with this regard, which is about, the third point you can write about write down the Tribunal Reforms Act, the Tribunal Reforms Act 2021. The Tribunal Reforms Act 2021 is the Tribunal Reforms Act 2021 is challenged before the Supreme Court. Is challenged before the Supreme Court. Is challenged before the Supreme Court in Madras Bar Association versus Union of India 2023. In Madras Bar Association versus Union of India 2023. In Madras Bar Association versus Union of India 2023. Is challenged before the Supreme Court in Madras Bar Association versus Union of India 2023. And the Supreme Court will decide, and the Supreme Court will decide whether, and the Supreme Court will decide whether the action of enacting an ordinance which has been struck down as unconstitutional, which has been struck down as unconstitutional, which has been struck down as unconstitutional is, which has been struck down as unconstitutional is, which has been struck down as unconstitutional is a violation of, is a violation of the Constitution, is a violation of the Constitution, is a violation of the Constitution, full stop. Okay, so you can leave about 1 page over here to find out what the current updates upon this, and this is a saga which is going to go on. At least what we have achieved in this class is a kind of a table of things that you can take a look at as to what are the ways in which this saga has been going on for so long, right? You can take a look at this particular thing. You have, SP Sampath Kumar 1987, L Chandra Kumar 1997, R Gandhi, State of the Bar Council, Bar Association of Madras 2010. Then you have Madras Bar Association versus Union of India 2014. Then you have Madras Bar Association versus Union of India 2015. Then you have Roger Matthew versus South Indian Bank 2020. Then you have Madras Bar Association versus Union of India 2021. And now you're having Madras Bar Association versus Union of India 2023. Along with it, there is the Finance Act of 2017. There is the Tribunal Reforms Ordinance of 2021. There are 2022 rules given by the Government of India, and then there are the Tribunal Reforms Act of 2021, which is being challenged currently. This is a kind of a whole, a chronology of these very complicated dates and events. Okay, the details of it may be complicated, but the concept is very simple. Let me repeat the concept again. The concept is with regard to the nature of tribunals, right? The question about, this is what is, the conundrum of a quasi judicial body. When we use the term quasi judicial, you may think it is a very nice fancy term to achieve a technical breakthrough, but no, it is actually a very kind of a contradistinction term, right? It says very simply this, that you have two arms of the state, right? You have the government, which, for example, let's say you have the uh, government, which is executive, right? And then you have the judiciary, which is the Supreme Court of India or the High Court. The question is, where do tribunals act, right? Now, the whole learning of this entire thing is that if you, for example, take a look at the functions of tribunals, they are judicial bodies. But if you take a look at the appointments of the tribunals, of the members of tribunals, they are executive body. And this kind of a mix and match of these two, this tug of war between the judiciary and the executive, has given a kind of a confused element to the tribunals, which is it is a quasi judicial body. What makes it a quasi judicial body? That the members of tribunals are very vehemently under the control of the executive in terms of their appointment, but they are acting as judicial functionaries. Okay, and everything that we have seen is that the Supreme Court is admitting to say it is right and correct in saying that, we are agreeing to the fact that Parliament can create alternate judicial bodies. The Supreme Court and the High Court and the lower courts are not the only bodies which can exercise judicial functions within the framework of the Constitution. The Parliament, under its constituent powers of Article 368, is is empowered to create a set of things which are in with regard to understood with regard to what you can call an action of the judiciary can be given to another body is created by the Parliament. So time and again in all the judgments you have seen, in all these 7 judgments, the Supreme Court has not said that Article 323A and B are incorrect. It says that the Parliament has the power to create alternate judicial bodies in and of themselves, right? But the Supreme Court has said that the government cannot keep the functions of appointing judges, because then that will dilute the nature and the quality of the judicial body, and then it will not be called a judicial body. And so long as the government keeps appointments under its control, then it is not a judicial body, it is an executive body, and therefore Article 226, 227 of the High Court will apply over it. Okay, so this is a position taken by the Supreme Court again and again very clearly. As long as you don't fix the problem of appointments, we are going to interfere by 226 and 227 in this entire matter, right? This was the SP Sampath Kumar and the Chandra Kumar, which are the two divergent opinions, and these kind of things have been reflected again and again in the follow-up decisions made by the Supreme Court in the Madras Bar Association cases, right? So that's the point. The details of this may be a little haphazard and complicated, and I've done my best to make sure that you have a kind of an organized way of looking at all of this. You see, you're getting an alignment or structuring of it is very perfect. But the concept of it is very simple. The concept is, what are the tribunals? Are they judicial, non-judicial, executive, or what is a strange term known as quasi-judicial, where they are appointed by the executive but have judicial functions. And till the time they are appointed by the executive, the Supreme Court has clarified that it is going to exercise powers over the judgment of the tribunal till the time they have the ability to maintain themselves as executive organs. They will be considered as such, and Article 226 and Article 227 writ petitions and appeals from tribunals will be taken up by the High Court. Right? Let us see what happens in the Supreme Court judgment in 2023 Madras Bar Association case. Right? So this is an entire saga of the tribunals completed. I hope that, though we've spent about the entire class on this, you are in a good position to have a very clear understanding with a very structured way as to what the tribunals are. You can see how intense this discussion is between the judiciary and the supreme and the government, and also you will be very sure to know that since it is going to be such a relevant part of the current affairs, it is going to be a question in the UPSC, and the UPSC has previously asked questions on the tribunals, right? So any question with regard to tribunals in GS paper number 2, you can solve them sufficiently by the coverage of these items, right? Okay. Let me take some questions with regard to tribunals, and then I can move on to the next part. Okay, so L. Chandrakumar case I have dictated now. Okay, this was a message at the start of the class, so that's now with your note. In fact, all the notes and tribunals are now with you. Okay. Shiladitya. Supreme Court on one hand uphold tribunal, on the other hand Supreme Court is saying NCLT and NCLT are unconstitutional. Well, they are not saying NCLT and NCLT are unconstitutional, but the appointment procedure is unconstitutional, which makes them unconstitutional. Right? Unless you fix the way of appointing the tribunal, then this kind of, they are not saying that NCLT and NCLT cannot be created. Please, make a point about this. The Supreme Court is not saying that these cannot be created. Okay, it is not saying that these cannot be created. Supreme Court is not saying that these cannot be created. What the Supreme Court is saying is that you can create them, you have the power to create them. We will not make a problem with you creating them, but if you keep the appointment of this under the executive, then on the basis of appointment we will declare them as unconstitutional. You see, there's a kind of a difference. It is not challenging the power of the parliament to create tribunals. It is not even challenging the Article 323A and B of the Constitution to be constitutional or unconstitutional. It is not even challenging what you call the whole idea of tribunal reforms as a point to be unconstitutional. But it is saying if the appointment are not thing, then how will you make, but you are contradicting yourself. You are trying to create a judicial body, and we are just saying that this is not a judicial body if the appointment is kept under the control of the executive. Okay. Biswajit. So currently, who appoint member of tribunal, cabinet members of parliament discuss or someone else? Well, the government, central government appoints the members of tribunals currently. The current situation is that they are completely under the control of the appointment made by the central government, which is the central executive, which means the Prime Minister of India has the most important role in the appointment of the tribunals. Okay. Okay, why is government of India doing the same thing again and again, though they know that the Supreme Court will strike it down? Is it just a waste of precious time of Supreme Court, which is already overburdened and lost our intellectual time who frame such act? Well, it's more than that. It's a political tussle between the judiciary and the government. And by the way, do you notice the fact that this has been going on since 1976, 1987, 1997, 2010, 2013, 2015, 2020, 2021, 2023. This is the timeline of this dispute, right? Out of these till here, it was the Congress government. And from here, it is the Bharatiya Janata Party government. But regardless of the political rivalry between the Congress and the BJP, both of them have been equally, partnered together with each other. Why do you think such laws pass in the parliament without any ho halla? Neither the BJP nor the Congress objects to these laws. The Congress has a habit of objecting against everything happening in the parliament. But when the Tribunal Reforms Act was passed by the parliament, the Congress did not say anything. Because when it comes to keeping the power of the government higher in comparison to the judiciary, the parliament becomes one. Right? The government becomes one. The political establishment becomes one when it is with regard to the government versus the judiciary. Now, all of these people don't have very much in common, these two political parties, but look at the continuity of how this kind of a thing is happening. This is what I want you to indicate, that it is not just a thing, it is about the fact whether the government can exercise a control over the Indian judiciary. And this is not a story which is only recent. This is a story which has been going on since the beginning of the constitution and has been exacerbated most prominently from 1967, the Golaknath judgment. Right. So this is a kind of a bigger political story, constitutional story about the war between the judiciary and the government in terms of having a power over the subjects of law. That's an example of this. So the government eventually says that it is, you know, empowered by the will of the people of India. And the will of the people of India finally has to have the final say in matters, and it calls the judiciary unelected tyrants who don't represent the people of India, who don't understand the people of India, who cannot relate to the people of India. They don't come from the people of India. These are elite ivory tower people who don't know how reality is. So they kind of think about laws as books and courts, etc., but never have they stepped in the middle of people and they've started understanding the position of the people as to what they're doing. So this kind of a tussle between the government and the judiciary is not something new, but it is certainly very intense on the case of tribunals. Okay, right? And does that become an answer to some of the question that you're asking? Okay, Anirvan. In R. Gandhi case, Supreme Court said to create a search cum selection committee, but in Tribunal Reforms Act, government done the same. Then why SC held it unconstitutional? Because that's a good question. The search cum selection committee created by the government had, in a way, given the power to the executive only to do it. You see, Mata, the membership of the committee was made in such a manner that it, let me, if you want, I can show you the membership of the search cum selection committee. That what is the membership? Here, take a look at this search cum selection committee. The chairperson, the members of the tribunals will be appointed by the central government on the recommendation of the search cum selection committee. First of all, the term recommendation is there. You know that recommendation does not imply binding. Okay. Second, the committee will consist of the Chief Justice of India or a Supreme Court judge nominated by him as a chairperson, two secretaries nominated by the central government, the sitting or outgoing chairperson or retired Supreme Court judge of India, the secretary of the ministry under which the tribunal is constituted. Right. So if you kind of take a detailed note of this, it looks exactly like an NJAC, in which eventually the power will be favoring the executive. You may apparently look at that the power is being given to the judiciary also, or there'll be a kind of a equal power sharing between the two bodies. But finally and eventually, the power is being handed over in the executive. And that's the problem that the Supreme Court is pointing out. That this search cum selection committee is called a search cum selection committee, but it is not fitting the criteria of maintaining an independence appointment, and therefore we cannot buy these as reforms, right? We are not going to let the government label them as administrative reforms or tribunal reforms. That's the point that the government has been objected about by the Supreme Court. Okay, Anirvan, doesn't answer your question. Okay, Shiladitya again. Judges cannot work in their things, in other things except being a judge. So how can he be appointed to tribunal if executive appointments are done by Supreme Court is obstructing? Well, see, the point is not judges can, obviously judges while they are appointed as judges cannot be members of tribunals, but after their retirement they can be members of tribunals, right? So there are, in fact, for example, NGT has the chairman who was a person by the name of Swatantra Kumar, right? This was a person who was the first chairman of the NGT, and Swatantra Kumar is a retired judge of the Supreme Court. So you can appoint judges after their retirement to different positions, for example, the chairman of NHRC, etc. Why not appoint them at the level of tribunals also, especially when they have the judicial understanding of things, they have had expertise on matters for some time or the other. Okay. Is there any fixed composition for all the tribunals? No. So currently, no. Each tribunal is determined by their own act. Again, for example, the NGT Act determines the appointment of its own members, the membership and the composition of its own members. So each tribunal currently is not under an umbrella formation because the Supreme Court has struck down the Tribunal Reforms Act. The umbrella formation has been rejected. There is only a singular act which governs the composition and the way in which each tribunal is working in its own regard. So there is no standard with regard to how many members should be there in each tribunals, etc., etc. It is singularly governed by the Act. This is with regard to the Madras Bar Association case 2021. The Supreme Court said that all of these search cum selection committee, etc., etc., they will not be valid. Go back to the same old methods of appointing the tribunals till you can find a better reform which can be standardized. Okay, so they're not, the point is that the Supreme Court and the government don't agree on the definition of what a tribunal reform is. Supreme Court is saying to the government that by passing this kind of an act, Bismay, you don't hold your nose like this, but you hold it like this, which is the fact that the executive is getting its power one way or the other anyway. So that kind of a thing is what the Supreme Court is saying is a problem with regard to the tribunal reforms, etc. Have these tribunals the power to issue arrest warrant against any person? Yes, 100%. If you, for example, take the NCLT, National Company Law Tribunal, if you are engaged in a fraud or if you're engaged in some kind of a scandal within a company, of course you can be arrested by the order of the NCLT. You can also be imprisoned by the order of NCLT. These tribunals are empowered under what is the powers given to the CPC and CRPC, right? The powers which are exercised by the CPC and CRPC, they're also given to the tribunals. Yes. Why the judgment of the tribunal cannot go to Supreme Court directly bypassing High Court? Well, it can go to the Supreme Court directly bypassing High Court under two conditions: under Article 32, writ petition, and Article 136, which is special leave petition. As a direct appeal, the Supreme Court itself has said that it has to first go to the High Court. Okay, that's the point. So Supreme Court under the L. Chandrakumar case said that a division bench of the High Court will be the appellate authority to look into the matters of the tribunals, right? But under Article 32 and under Article 136, the Supreme Court can be approached directly. Okay, so this new amendment in forest conservation will restrict the application of Supreme Court judgment in the Godavaraman case. Can this act be challenged in Supreme Court for not following Supreme Court judgment? Well, I have not read this particular amendment yet. Can you please give me a day's time to get a sense of what this is about? I'm not sure if I have been able to follow the monsoon session of the Lok Sabha abhi currently, but let me just go back to it and see what they are saying about it. We are reading that in India has three organs: judiciary, executive, and legislative. But sir, in YouTube, in a court video, judge asked some IAS officer who is above government direction or high court. So who is above? Even I have myself heard that judicial magistrates was saying bank administration rules are not above me. My position is above bank administration rules. Okay, so the video that you have seen, I have also seen that video in which an IAS officer was summoned by the High Court. I think it was the High Court of Madhya Pradesh, in which this was telecast, right? It's a kind of a very angry judge of the High Court of Madhya Pradesh, Jabalpur High Court it was, I guess. Yeah. So he was saying to the IAS officer that when we summoned you, why did you not come? Right? That's not. Now, the Supreme Court is not necessarily above the government, but when the matter in that case was under Article 226, which was a violation of a fundamental right of a person. Now, you know, for example, under fundamental right violation, you have the Supreme Court has extraordinary, the High Court and Supreme Court have extraordinary powers called the writ powers, by which they can exercise a lot of actions, right? And these are to be taken urgently by the Supreme Court. So when it comes to protecting fundamental rights, Supreme Court is higher than the government. And for these, special provisions are made under Article 32 and Article 226. And that matter that you saw was a question of a writ petition filed under Article 226, in which the government must have violated the fundamental right of some person. He must have filed a writ with the High Court, and High Court asked the government to come and tell what is the problem, and the government was not coming. And therefore, the High Court said that why are you not coming in a matter which is a question of fundamental right? With this regard, who is higher, the High Court or the government of India? And of course, the High Court is higher with regard to the fundamental rights. Okay. Now, this kind of a thing is not correct. Judicial magistrate does not have the right to say that bank administration rules are not above me. My position is above the bank administration rules. This is not correct. This must have been said in a little bit of a presumptuousness. So, possible, please mention important article of Indian Constitution which we should study for details for exam purpose. Okay, fine. Let me circulate a list later on. If judges are appointed after retirement, judges will act according to executive. Isn't that unconstitutional? If judges are appointed after retirement, judges are appointed after retirement, judges will act according to the executive. Isn't it unconstitutional? Yes, if the executive appoints judges. But if an independent, let's say for example, if a National Tribunals Commission, let's say a UPSC like body appoints judges with a private, kind of a, with the, just imagine a UPSC format, just a thousand times more sophisticated. That retired judges of the Supreme Court have to go through an examination, then an interview panel, then a personality test, a kind of a neutralized way of assessing merit, and they are given to the tribunals. Then there is obviously no executive control on that. So it is not about whether judges are creating a kind of a prejudice, but the fact that the executive is handpicking the judges who it likes and ignoring the judges who are actually honest. You see, that would create a bit of a thing. Okay. Pritam, some study material, RPA, RTI, and Citizens Charter. Well, RTI, I think I've given almost everything in the form of notes, which is the RTI Act. With the Citizens Charter, I just have to give that document. Fine, I'll just circulate it in the WhatsApp. Please tell me what are the things that I had told that I would give on RPA. I have made you write the sections of RPA, etc., etc. The RPA Act is there. 90% of what you have to read is in your notebooks. You have written that already. Whatever little is remaining, please specify if you remember what I have told you. I'll just leave the documents in the PDF format on the chat box. Okay. All right. So just let me briefly give you a simple understanding of what is the National Tribunals Commission. Right. Now, there's a beautiful article written in the Hindu newspaper about the NTC, which is a good way of covering the parts of NTC clearly with us. Okay. National Tribunals Commission, NTC. Now, this is of course the final solution as given by the Supreme Court to finally, kind of create a solution to this entire problem of the tribunals. Okay, restructuring the tribunal system. This is the reform. If a question is asked that what are the reforms which can be initiated to, solve the whole problem of tribunals, that is to create a National Tribunals Commission. Take a look at this. One of the main reasons that has motivated the idea of NTC is the need for an authority to support uniform administration across all tribunals. The NTC could therefore pave the way for a separation of the administrative and the judicial functions carried out by various tribunals. A corporatized structure of NTC with a board, a CEO, and a secretariat will allow it to scale up its services and provide requisite administrative supports to all tribunals across the country. Okay. The NTC would ideally take on some duties relating to administrative and oversight. It could set performance standards for the efficiency of tribunals and their own administrative processes. Importantly, it could function as an independent recruitment body to develop and operationalize the procedure for disciplinary proceedings and appointment of the tribunal members, giving the NTC the authority to set members' salaries, allowances, and other service conditions subject to regulations would may help maintain tribunals' independence. Administrative roles of the NTC include providing support services to tribunal members, litigants, and their lawyers. For this purpose, it would need to be able to hire and supervise administrative staff and to consolidate, improve, and modernize tribunals infrastructure. Okay. So you see the point. This is basically what the concept of NTC is. Idea is to create a UPSC-like body. Union Public Service Commission is a body which is involved in solving a lot of problems, which could have been more dynamic if the question was how to appoint IAS officers was asked. But UPSC has to some extent given that answer of right. So the idea of NTC was first mooted in L. Chandra Kumar, but it has not still seen the light of the day. Okay, so you get the point. And in the later cases also the Supreme Court has talked about the NTC. So this is supposed to be the final solution, and you may hear a little bit about the NTC in the coming judgment of the Supreme Court. So please keep your eyes open with regard to that judgment also, and the mention of the NTC, etc. Right? I'm going to just forward this article as a PDF for you to read as notes of the National Tribunals Commission, which is like again a UPSC-like body for the appointment of the members of tribunals, so that the independent appointment problem of the tribunals can be completely solved once and for all, right? And Supreme Court, under the current Chief Justice, is going to push the government to create a reform like this. Okay, so this is one sensational thing that will develop out later on between this thing. Well, Kaushik, just please let me first cover the parts which are allotted to me under the subject of governance. We are still, due to cover some things because the kind of detail that we're doing with governance. I want to first finish my protocol allotted to me, which is regarding governance. Be sure I will find one way or the other to address questions which are related to polity. Now, majority is Article 100, which is in the subject of polity, but please make sure that I am first and foremost involved in covering the questions of governance, and that's one thing that I want to focus upon. After that is done, maybe in a different way and depending upon the intensity of the demand you have, I can have a special session organized for this particular part on polity, etc., etc. Okay, but my duty is a priority at this point of time with regard to governance. um, okay. Right, so Thika, we can break for some time, have lunch and come back and start with the last remaining parts of governance, and let's see how far we can go. And then we can organize for some special session to cover the remaining of them, okay? If you want some areas to be covered in other parts which are not directly under the protocol what I've given, you can please make a request about it, and then we can have an organized way of doing it. Thank you.